Boom! You know, bro, got vibrant, bad like way power and rory. But here what? At the time for the lion, them tell them story. Lion voice. A bro, got vibrant. I said, don't listen to it once, don't listen to it twice. Subscribe, like, and share. You hear? Boom! Cause just because I hear them. Cause them a fast and pray just to see we fail. Lion voice. Boom, got vibrant. Rep.
You know, this is where it gets sticky for Steely and Clevie because, you know, the rhythm, the chord progressions, the beat, the drum pattern, these are things that US copyright are more leaning to saying cannot be protected because it would create haywire because, you know, if you can own a genre, then it's going to stifle, you know, if you go back to the root of the copyright law, which is to stimulate innovation and creativity. If somebody can own an entire genre, then and I'm not saying that I agree because obviously they took Jamaica's rhythm and created this genre, so there should be some credit or some benefit that goes to Jamaican creatives for this. However, from a legal perspective, the argument is, you know, if someone can create a genre, they can monopolize and therefore stifle innovation.
Well, Lion Voice, tell them that's the people first choice. Lion Voice, make the lioness them feel nice. Lion Voice, with the lion cubs we sacrifice. Lion Voice, got to show the people them the life. Lion Voice. Yeah, go up on North Road. Haile Selassie the first. Children. Well, you're gonna do two things when you hear this song. You either gonna move or you gonna leave. You have to move. Either way you gonna bounce or you have to rest. You have to bounce. I tell them bounce, I tell them bounce, tell them bounce. Can't buy my soul for no bank account. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much they can't count. Would you sell your people poison to make a dime? If you knew that they were dying, would you change your mind? Would you embrace crime? Would you risk life in a cage? Or would you even care as long as you got paid? You never been a slave, still you slave for the cash. If the price was right, you would have sell your ass. Far as I can see, you don't know your past. You just a follow dirty Babylon till Babylon crash. Tell them bounce, I tell them bounce, tell them bounce. Can't buy my soul for no bank account. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much they can't count. Tell them bounce, I tell them bounce, tell them bounce. Work hard for my money, work for large amounts. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much they can't count. Would you put on a dress? Would you put on a blouse? Would you do anything just to move the crowd? Would you take off your clothes? Would you spread out and pose?
Greetings in that divine name of His Imperial Majesty, Emperor Haile Selassie I. Glory and honor in the name of His chosen Queen, Empress Waziri Menen. My name is Kwasi Bansu, aka Dejazmatch Kwasi, aka Ras Kwasi, aka the Reading Ras, aka the Pan-African Happy Man. I'm a creative industry attorney, I'm an artist, I'm an actionist, I'm an author, and right now, I'm the host of the Lion's Voice. Welcome to the Lion Voice Network and welcome to Lion Law, where we talk about topics that are relevant to creatives within the creative industry from a legal point of view. Today we have a very interesting episode. We're going to follow up on a groundbreaking litigation. What am I talking about? I'm talking about Steely and Clevie, two of our reggae dancehall icons, suing basically the entire reggaeton genre. We did an episode earlier about this. It was one of the first episodes of Lion Law. It might have been the first episode of Lion Law where we talked about this. And so we promised to give you an update. The case is at the point now where they're getting ready for arguments. So we just wanted to bring you up to speed because every creative should be watching this case. This is groundbreaking stuff. We also did an episode about the groundbreaking case with Ed Sheeran, who won a copyright infringement litigation. And I told you in that episode that this is going to have ramifications, and that case is being brought up in this case. So we're going to read from Dancehall Magazine and get an update. Big up the writers and the editors over at Dancehall Magazine. They're doing excellent work. I was reading, doing a little research for the case, reading a Rolling Stone article, and I see that even Rolling Stone now is quoting from Dancehall Magazine. So they've definitely done their job, established themselves, as a source, credible source in the music business. So big up Dancehall Magazine for bringing journalism and raising the standard in terms of reporting on these matters. So we're going to read that. I'm going to just give my thoughts as we read from the Dancehall Magazine article. My first video, we had some brilliant people comment in the comments. Drop a comment, let us know what you think in the comment section. Before we go there though, I have to just say big up to the Lion Pride. Big up to the Lion Pride on Patreon. How do you become part of the Lion Pride, you ask? If you subscribe, you are part of the Lion Pride. We are growing on this channel rapidly now. We've passed 1,500 subscribers. I remember when we were at 100, less than 100 subscribers. We're over 1,500 now. We just broke 17,000 views in the last 28 days. We broke 10,000 unique viewers on the platform. So we're hitting all of these milestones, and these are modest. Don't get me wrong. For creatives, these are modest, but on the Lion Voice Network, we believe in celebrating our victories as they come. It's not about the destination, people, it's about the journey, and you have to celebrate your wins no matter how small. You remember, if you go back, I'm celebrating because I had 100 views on a video. Now we're doing 100 views in a day. Easy. If we don't hit 100 in a day, the videos are considered somewhat underperforming. So I remember when a week, if I hit 100 in a week, I would celebrate. So there's stages and there's levels to everything. You got to start somewhere. Start your creative journey. And as I say that, we are available for consultations. You can book a consultation, creative consultation, or a legal consultation. Just go to the website. You see the Dejazmatchkwasi.com. Book your consultation. Use us as a sounding board and we'll help you to develop your creative ecosystem. We'll also help you with your legal direction in terms of doing some due diligence, legal audit of your creative business to make sure that you're structuring it the right way for the long term. So those services are offered. Also, join us on Patreon. We have exclusive content on Patreon. Big up the Lion Pride on Patreon. We are on a Patreon campaign right now. I need to get 1,000 people into that Patreon by September 11th of next year, Ethiopian New Year. We're moving into 2016. We have and we're gonna use that as a mark. And by the next year, Ethiopian New Year, we want 1,000 of the item in the Patreon. So if you're part of the Lion Pride, consider supporting the channel by going more deep into the Patreon so that we can use that investment to help to raise the standard. We want to build a production studio in Ghana, West Africa. I am currently planning my repatriation journey. I'm going to be sharing it right here on the Lion Voice Network, primarily on the Patreon. So support us on the Patreon. We just dropped an exclusive full episode with Dr. Akililu, the former president of Haile Selassie University. So all of that is happening. We have the Dejazmatch Kwasi, the Reading Ras merchandise, all of those things as part of our creative ecosystem. So support the platform. You love the content. You've been saying you love the content. You see that we are consistent with the content. Support the content. Give thanks. We had to do the housekeeping. Now let's get forward to the topic. We're going to, again, read from Dancehall Magazine and give you an update on this groundbreaking litigation. So, first and foremost, we have to credit Danny Malak, who was the writer of this article. The sister, bless up Danny Malak. And I'm going to just read, and then like I said, I'll just jump in with my commentary as we go along. It says, 107 of the almost 170 defendants in the Steely and Clevie Productions copyright lawsuit filed 3 motions on Thursday, June 15, to dismiss the case. The 3 California court filings obtained by Dancehall Magazine reveal that the defendants' primary defense, the drum and bass elements allegedly pirated from Steely and Clevie's 1989 Fish Market Riddim and used in almost 1,700 reggaeton songs, are commonplace and not subject to copyright protection under US law. So just let's talk about that, because the underlying assertion to this case is that the drum pattern, the rhythm, it was unique enough that it deserves copyright protection. I told you when we did the episode on Ed Sheeran, where the estate of Marvin Gaye was suing Ed Sheeran for the chord progression and the rhythms. It's getting harder as the law evolves to protect rhythms. And they're saying these are basic elements that are in all type of songs, and you cannot protect those. So this may affirm where the court was going with the Ed Sheeran. We don't know yet, but the attorneys are making this assertion. So this is going to be a tough case for the Steely and Clevie side. Let's continue. According to them, the Jamaican producers Cleveland Clevie Brown and the estates of the late Wyclef Steely Johnson and Ephraim Count Shelley Barrett cannot claim ownership in the basic musical elements that define nearly all reggaeton music created over the last 30 years. The first motion was filed by WK Records, Pitbulls, Mr. 305 Inc., Yandel and Winston, Malimu, Mike Tower, and 9 other defendants responsible for 376 songs named in the suit. These defendants put forth an intriguing analogy. The rhythm of reggaeton, they argue, is akin to defining the foundational features of other musical genres, from the downbeats of reggae to the 4 standard chords of rock music, E, B, C minor, and A, and even the recurrent rhythmic patterns found in salsa music. Plaintiffs claim ownership of an entire genre of basic core music, the rhythm of reggaeton, based on simple, rote, unprotectable common music elements, which are nothing more than common drum beats of single notes, they wrote in their motion to dismiss the case. Puerto Rican superstar Bad Bunny and his label Ramas Music, responsible for 77 songs named in the suit, presented a similar defense. In their motion to dismiss, they argue that Steely and Clevie's lawsuit impermissibly seeks to monopolize practically the entire reggaeton musical genre for themselves by claiming copyright ownership of certain legally irrelevant and or unprotectable purported musical composition elements. They cited precedent cases where courts have been consistent in finding rhythm resulting from jump patterns and bass to be unprotectable. The WK Records and Bad Bunny defendants urged the court to dismiss the case, contending that no reasonable jury could find 17,000 songs substantially similar to Steely and Clevie's old and obscure Fish Market. Meanwhile, the third motion to dismiss was filed by Louis Fonzi, Justin Bieber, Daddy Yankee, Pitbull, Ryu, I'm going to butcher these names, so read the article, forget them names, but whole heap of people filed these motions to dismiss. Update. Since this article was published, the following defendants who are not represented by prior Cashman LLP have co-signed the law firm's motion to dismiss. Drake and Sound 1.0 Catalog LP, improperly sued as OVO Sound LLC, DJ Snake and Empire Distribution Inc., Sync Music Group LLC, Sync Music Publishing LLC, Rich Music Inc., DJ Nelson and Jay Wheeler. They argue that Steely and Clevie were trying to obtain ownership of an entire genre of music by claiming exclusive rights to the rhythm and other unprotectable musical elements common to all reggaeton-style songs. They also said the lawsuit should be dismissed for numerous procedural reasons, including the claim that Steely and Clevie do not have standing to assert infringement claims for any of the alleged derivative instrumentals based on the fish market. Steely and Clevie's 228-page complaint, the first version of which was filed in 2021, has traced the trajectory through which nearly all reggaeton alleged appropriated elements from derivative versions of the original fish market. It started with the fact that Shabba Ranks' Dembow 1990, produced by the late Bobby Digital Dixon, had used a fish market beat from Jamaican vocalist Gregory Peck's Pokemon Jam and one of the 1989 tracks on the Steely and Clevie's original Riddim. In 1990, after the success of Shabba Rankin's song, Dennis Halliburton, aka Dennis the Menace, created the Pounder Riddim, a remake of Dembow's instrumental, which was then used to record a Spanish language cover version of the song titled Elios Benia, an instrumental mix called Pounder Dub Mix 2. Elios Benia was released on the plaintiff's Count Shelley's records, Shelley Records. Pounder Dub Mix 2, Steely and Clevie claimed is substantially similar, if not virtually identical to Fish Market, and has been sampled widely in reggaeton and is commercially known as the Pounder Riddim. However, Louis, Fonzie, and Justin Bieber defendants countered that Steely and Clevie's copyright claims could only extend to the Fish Market and the lyrics of Dembow, for which they had a valid US copyright registrations. They claimed that Steely and Clevie lacked copyright registrations for Dembow sound recording, the Pounder Riddim, and only secured registration for the Pounder Dub Mix sound recording in March 2023, 2 years after filing the lawsuit. US regulations require copyright registration before a suit is commenced, they argued. All 107 have suggested that the court set hearings on the motions in September 23 or sometime thereafter. So this is a tough case. It's not open and shut case. There's so much hurdles. The opposition is putting forth strong arguments, and they also are asking for attorney's fees. So if they prevail, it could end up that Steely and Clevie and now Count Shelley, who has been added to the suit so that they could, confidently claim the Pounder Riddim, which is the rhythm that was sampled. They could end up having to pay attorney's fees, which could, with so many defendants, could be in the hundreds of thousands, if not millions of dollars. So this is high stakes legal drama. The article goes on to say 17,000 songs at issue in the lawsuit were released between 1995 and 2001 and have amassed tens of billions of views on YouTube and many RIAA platinum and platinum certifications in the United States. And the article goes on. I'm not going to read the entire article. I'm going to jump down to the part where it talks about, is Ed Sheeran's case similar? It says in 2022, British pop singer Ed Sheeran submitted a motion to dismiss the copyright lawsuit filed against him over claims that the song Thinking Out Loud had stolen harmonic chord progressions from Marvin Gaye's Let's Get It On. Sheeran's lawyer, Prior Cashman LLP, the same firm that's in this case representing Fonzie, Bieber and others against Steely and Clevie, admitted the songs had similar chord progressions, but argued that the chords are generic and can be used by anyone. A US judge denied Ed Sheeran's bid to dismiss the case, ruling instead that the jury should decide on the similarities between the song and that of the late Motown singer. The judge cited the disagreement between musical experts on both sides of the lawsuit as a reason for ordering the civil trial. According to the BBC, the idea of a jury trial was something that Sharon did not desire, as copyright lawyers have often argued that not only do juries have difficulty of understanding the complexities of copyright law, but they are not okay with the reason superficial similarities between two songs are not necessarily proof of plagiarism. In May 2023, the jury ultimately found Sharon not liable for copyright infringement, The Guardian reported. In 2021, acclaimed, and let me just say about that, this is where it gets sticky for Steely and Clevie, because, the rhythm, the chord progressions, the beat, the drum pattern, these are things that US copyright are more leaning to saying cannot be protected, because it would create haywire, because if you can own a genre, then it's gonna stifle, if you go back to the root of the copyright law, which is to stimulate innovation and creativity. If somebody can own an entire genre, then and I'm not saying that I agree, because obviously they took Jamaica's rhythm and created this genre, so there should be some credit or some benefit that goes to Jamaican creatives for this. However, from a legal perspective, the argument is, if someone can create a genre, they can monopolize and therefore stifle innovation. And so the courts are going to be more leaning toward allowing for these things to be not protectable, or for ruling that these elements are not protectable, so that more people can create more works that then can be protected and copyright, and the economy can be stimulated, because more songs will go platinum and this and that, and it encourages more creatives to get into the market. So these are the backbone copy. We are dealing with the backbone of copyright law, so that's why these cases are so fascinating. I'm going to just seal up. I'm not going to read the entire article. I'm going to put a link in the description so you can go check it out. But this is high stakes. This is better than Law and Order. Check it out, please, my family. Make sure we keep in tune with what's happening. I'll just read the last part, which is a quote from King Jammy's. It says, in 2021, acclaimed Jamaican producer Lloyd King Jammy James commended Clevie for filing the lawsuit, since, according to him, reggaeton artists have frequently infringed on the intellectual property rights of Jamaican musicians, and he hoped the lawsuit would set a precedent for future actions. Well, I think Clevie is following the right track, because what happened? Those people mostly sample our things, and the way them do it, sometimes you have to be somebody who technical to hear the sample and to know the sample, Sling Ting co-producer told Winford Williams on stage. And they don't give us any rights, so our rights are being stolen. So I think it's a good thing Clevie is doing right now, by setting an example that those who are going to do it again, don't worry, do it, he added. So that's from the legendary King Jammy. So of course, Jamaicans, we are mostly united on this topic. But will the courts rule in favor of Steely and Clevie? Will Steely and Clevie have to pay attorney's fees? So much to ask, so many questions there. So keep in touch. We're going to keep you posted here. So if you're not subscribed, make sure you subscribe, like, share. We're going to keep you up to date. This is cutting edge on the legal aspects of the creative industry. This case is going to have massive implications. So definitely make sure you stay locked. Why? Because the time has come for the Lions to own our own story. And this is the Lion's Voice.
Lion voice. Yeah. Grow up on North Road. Haile Selassie the first. Children. Well, you're gonna do two things when you hear this song. You either gonna move or you gonna leave. You have to move. Either way you gonna bounce. Or you have to rest. You have to bounce. I tell them bounce, I tell them bounce, tell them bounce. Can't buy my soul for no bank account. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much they can't count. Would you sell your people poison to make a dime? If you knew that they were dying, would you change your mind? Would you embrace crime? Would you risk life in a cage? Or would you even care as long as you got paid? You never been a slave, still you slave for the cash. If the price was right, you would have sell your ass. Far as I can see, you don't know your past. You just a follow dirty Babylon till Babylon crash. Tell them bounce, I tell them bounce, tell them bounce. Can't buy my soul for no bank account. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much you can't count. Tell them bounce, I tell them bounce, tell them bounce. Work hard for my money, work for large amounts. I tell them bounce, I tell them bounce, tell them bounce. Blessings where we got too much they can't count. Would you put on a dress? Would you put on a blouse? Would you do anything just to move the crowd? Would you take off your clothes? Would you spread out and pose just to get some diamond and some gold? Would you call your people nigger, then ask them to wave? If your people were in trouble, then how would you behave? If the beast came out the cave and started to rage, would you be afraid? Or would you tell them bounce?